Welcome to this webcast on corporate governance. My name is Phillip Brophy from Matthews Folbigg Lawyers in Parramatta, and I look forward to presenting to you. Good corporate governance is at the heart of legal compliance and corporate success, yet the publicity it receives is often for the wrong reasons. So how can you achieve a sensible level of governance for your particular business? Let's start by looking at what is corporate governance. Corporate governance should be thought of as having both internal and external components. Internal corporate governance deals with the management and control of the company, including such matters as compliance with the company constitution and internal rules, policies and procedures developed by the company itself, decisions of the board of directors and the shareholders at a general meeting. These are the two main organs of the company. Relations between the board and shareholders, which relates to issues such as accountability, transparency and disclosure. Internal controls and audits. These can be financial, but also can relate to privacy and confidentiality of customer and client information. External corporate governance deals with regulatory compliance and external relations of the company, compliance with laws and regulations, relations with external stakeholders, government regulators, external auditors. There are ASX for listed companies, customers, clients, trade unions, professional associations, licensing authorities and the community. It relates to things like corporate communications policy and PR and corporate social responsibility. We will focus today on internal corporate governance, but also touch on the relevant external corporate governance principles and best practice as well. So where do corporate governance rules come from? The source of corporate governance rules include the company constitution, the Corporations Act, any laws or regulations which might affect the company, such as environmental laws, work health and safety laws, the Fair Work Act, the ASX listing rules for publicly listed companies, and contractual arrangements such as shareholders agreements commonly found in smaller companies. There are also well-established best practice principles which we will be exploring today. So why is corporate governance important? There have been many recent corporate scandals in Australia which are the result of poor corporate governance. Two examples spring to mind. The Banking Royal Commission resulted in allegations against the AMP and the banks, which received a lot of adverse publicity. Also, the example of 7-Eleven, where there'd been systematic underpayment of employee wages by franchisees. Franchisees had concealed the underpayments and falsified records in some cases. Head office, the franchisor, was either aware of this or was negligent in its supervision. Franchisees have faced penalties and fines, and it has resulted in amendments to the Fair Work Act, which now makes franchisors liable in some cases for the defaults of their franchisees. As these examples demonstrate, a lack of internal controls and management oversight can result in non-compliance with the law, damaged relations with external stakeholders such as customers and the public, as well as the internal stakeholders, the shareholders, reduced profitability, increased attention from regulators and regulatory blowback such as enhanced red tape, permanent and lasting PR damage, and probably, very importantly, a loss of wealth for shareholders from share price falls. On the other hand, good corporate governance will result in the company not only fulfilling its legal obligations, but can also improve company performance and profitability, will result in a positive organisational culture and good relations with both external and internal stakeholders, and will boost the goodwill and brand image of the company and thereby boost shareholder wealth. In this presentation, we will explore directors' duties and liabilities, including how to manage risk and conflicts of interest, the administrative and reporting duties of companies, which must be performed by the company secretary, or if there's no secretary, the directors, the financial record keeping and reporting obligations of the company, shareholder rights and liabilities, and how the company and directors should engage with shareholders. We will be focusing on the needs of non-listed companies. As always, we aim to provide practical, commonsensical and actionable guidance to help you achieve good corporate governance. So what is the role of a company director? Directors are responsible for managing the affairs of the company and for driving it forward. And I would emphasise the word driving it forward. The directors are the ones in the driver's seat. Directors may exercise all the powers of a company except those reserved to the shareholders in a general meeting. I'll return to this concept later. Directors are responsible for formulating company strategy, ensuring the company achieves its objectives such as profitability, and setting company policy. The directors represent the company to internal stakeholders such as the shareholders and external stakeholders such as ASIC. Directors are also responsible for holding management and employees to account, and this relates to areas such as risk management. Directors may delegate some of their powers to management and employees, although they will generally remain liable for the exercise of those delegated powers. So this leads to the important question of who actually should be a company director. Proprietary companies must have at least one director, while public companies must have at least three. At least one of those directors must ordinarily reside in Australia. A director must be a natural person. In other words, whilst a company can be a shareholder of another company, it cannot be a director. A director must be at least 18 years old, have consented to be a director, not be an undischarged bankrupt, not be convicted of certain criminal offences, and not be disqualified from acting as a company director. It is good governance for companies to appoint directors with broad experience, skills and qualifications, such as a person who understands the industry and the commercial world generally. Ideally, directors should have some legal and or financial qualifications or training. Ideally, the board should have some independent, non-executive directors who can provide an outside perspective. Directors should be knowledgeable about their duties and obligations. The Australian Institute of Company Directors, for example, provides training courses for directors. Directors should not have a conflict of interest, and we'll return to that concept later. And directors should be people who have the capacity to attend meetings and to commit their time and resources to the organisation. That's particularly important in the not-for-profit sector, where those people typically are not paid. So they should recognise that whilst they aren't paid, there is a responsibility to commit their time and resources to the role. It's also good governance for companies to have an induction process for newly appointed directors and for a chairman, particularly if that chairman hasn't risen through the ranks of the directors. So what are directors' duties? Directors' duties arise under the Corporations Act, the company's constitution, the law generally, and contractual arrangements such as executive service agreements. Directors' duties include an obligation to exercise due care and diligence in the performance of their powers to the standard of a reasonable director in the same circumstances, to act in good faith in the best interests of the company, to exercise their powers for a proper purpose, and not to improperly use their position or information they obtain from their position to benefit themselves or others to cause detriment to the company. They have a duty to avoid conflicts of interest between their duties as a director and their personal interests, to avoid conflicts where the director holds multiple directorships. Clearly, the duties owed to multiple companies may very well conflict. There is a duty to exercise independent judgment, to maintain accurate financial records, to report to ASIC on the financial affairs of the company if required, and to notify ASIC of any change to the company's registered details. Importantly, there is a duty to prevent the company from trading whilst insolvent. In other words, a company must be able to pay its debts as and when they fall due. So what are the liabilities of company directors if they get it wrong? Provided that a director complies with his or her duties, they will generally not be liable for the debts of the company unless they have given a personal guarantee for those liabilities. However, a director may be liable to pay compensation, in other words, damages to the company if the company suffers a loss due to the director's breach of duties. The director may be liable to pay restitution to the company for any unlawful gains the director makes in breach of his or her duties. The director may be personally liable for the debts of the company where the company was trading whilst insolvent, which can also be a criminal offence. There could be a liability to pay fines of up to $200,000 if the director breaches any of the civil penalty provisions of the Corporations Act. The company itself may be liable for a fine of up to $1 million. The director may be guilty of a criminal offence for breaching certain provisions of the Corporations Act, which with punishments including fines of up to $200,000 and up to 5 years imprisonment. The director may be disqualified from serving as a company director if they breach certain provisions of the Corporations Act. An application for disqualification would have to be made by ASIC. The director may be liable as an accessory for breaches of various other legislation, including the tax legislation, that relating to workplace health and safety, the Fair Work Act and the Australian consumer law. Aside from these penalties, a director's employment or contractual arrangement with the company may be terminated as a result of the director's default. A director may suffer significant reputational damage and have difficulty finding future employment. A breach of director's duties may trigger the buyout provisions under a shareholders agreement, and the director could lose control of his or her shareholding. A director may also find overseas travel difficult if convicted of a criminal offence. Defences apply, such as the business judgment rule and the new safe harbour protections, and directors may be able to obtain indemnity insurance to cover some of their risks. That's beyond the scope of the paper today, but please contact me if you would like specific advice or assistance. So how should a director deal with conflicts of interest and related party transactions? Directors, other than sole directors of a proprietary company, are under a duty to disclose to the board any material personal interest they have in a matter or transaction affecting the company. A material personal interest arises where the personal interests of a director or their family, friends or other organisations they are involved with are incompatible with or compete with the interests of the company in which they are director. Examples include where there are direct or indirect financial benefits for a director or an associate as a consequence of a transaction. The director or an associate is a customer of or a supplier to the company. The director sits on 2 or more boards and has conflicting duties owed to each company. There need not be an actual conflict, only a real or substantial possibility of one, and the mere perception of a conflict of interest can damage the reputation of the company and its board. A type of conflict of interest is a related party transaction between the company and a person or entity related to the company. Examples include a company purchasing supplies from another company wholly owned by the director of the first mentioned company, a supplier to the company offering gifts or discounts to the spouse of a director, a contractor of a company employing the relative of a director of the company. A related party transaction is problematic when it is not in the best interests of the company as a whole, when it is not at arm's length. It could result in the company getting a bad deal, or a director or his or her family or friend receiving a benefit in exchange from steering company business to the related entity. It also carries reputational risk for the company. So how should you deal with conflicts of interest and related party transactions? The company should establish a policy including requiring the company and directors to maintain a register of interests of directors, similar to that applicable to politicians, and a record of the related parties of the company, such as a list of suppliers and contractors of the company. The policy should require companies to complete a declaration of interests and a declaration of their related parties upon appointment and to keep them updated. This can be a condition of their employment, contracts, or the board code of conduct. The policy should require the director to declare interests as and when they arise, and if disclosed in a meeting, they should be recorded in the minutes. This can be a standing agenda item at board meetings. The policy should set out that a proper tender process should be undertaken for all company contracts, for example, requiring formal tender proposals, quotes from at least 2 or 3 other competing business. The policy should address hiring family members, accepting gifts from related parties, and should require independent external advice to the board when in doubt, and should also mandate proper documentation of all related party documentation, of all related party transactions, such as written agreements, formal approval from the board documented in the minutes, including an explanation of why the company entered into the transaction and the process it followed. The above recommendations in some cases go beyond the legal requirements. The Corporations Act provides that proprietary companies generally do not require shareholder approval for related party transactions, and that directors of proprietary companies are generally entitled to vote on and profit from matters or transactions in which they have a material personal interest, provided they have made a proper disclosure. Public companies, on the other hand, must obtain shareholder approval. The bottom line is that conflicts of interest must be managed and disclosed, and related party transactions must be in the best interest of the company, otherwise the directors will be in breach of their duties. So how do you manage risk? Directors are under a duty to exercise their power with due care and diligence to a standard of a reasonable person in their position. It is good governance for a board to have in place a risk management policy, which includes a mission statement on risk, a description of the organisation's risk tolerance or risk appetite level, a provision for a risk management committee and internal and external auditing of the accounts and financial performance, a risk register which identifies and manages risks, a periodic review of those policies. An effective risk register will identify risks such as financial, strategic, market, workplace and health and safety risks, environmental risks and PR risks. Should assess the level of risk that the company it finds acceptable and the likelihood of the worst case scenario materialising. The policy should implement risk controls such as auditing, risk management committees and lines of reporting. The policy should nominate people such as managers who will monitor and manage the risk and report regularly to the board. Ultimately, it is the board that is responsible for risk management and for instilling a culture of risk-taking or risk aversion in the organisation, preferably something in the middle or in between. Now, clearly directors can't do everything, so there comes a need for delegation. Subject to the company constitution, directors may delegate some of their powers to a committee of directors, to management or employees. That's why they employ people. Delegations of authority could include authority to enter into certain contracts, buy or dispose of property, take out a loan on behalf of the company, or operate the company's bank account. It is good governance for a company to issue a written instrument of delegation signed by the directors, clearly setting out the extent of the delegated powers, the persons to whom the authority is delegated, and whether the powers can be subdelegated. A good governance to maintain a register of delegations and to keep it current so other staff members are aware, and to properly record any delegation of authority in the company minutes. Generally, a director who has delegated his or her authority will be responsible for the exercise of that power by the delegate, except where the director reasonably believed that the delegate would exercise the power in accordance with the Corporations Act and the Constitution. The director believed on reasonable grounds in good faith and after making proper inquiry that the delegate was reliable and competent to carry out the delegated power. Therefore, by documenting the delegation of authority and the reasons for the delegation, a director can limit his or her liability. It also provides protection and guidance for the delegate. Reliance on the advice of others is something we need to look at. Directors are under a duty to exercise their powers with due care and diligence and to exercise independent judgment. These duties are to be exercised personally by the directors. Whilst the directors can delegate their powers, they generally cannot outsource their responsibilities. A director can rely on the advice and information provided by an employee, an external expert or advisor, such as an accountant, auditor or lawyer, or another director of the company, provided that the director believes on reasonable grounds that the employee or advisor is competent and the matter is within that person's expertise, and or the other directors were acting within their authority when they provided the advice or information to the director. The director's reliance must be reasonable, and the director must act in good faith, make an independent assessment of the information or advice, and have regard to the director's knowledge of the company and the complexity of the structure and operations of the company. Therefore, the directors cannot simply rely on the advice of others. Their reliance must be reasonable. They must make an independent assessment of the information or advice. As ever, ignorance is no excuse. The directors cannot avert their eyes from issues affecting the company and must remain informed at all times and exercise their powers with competence and independence. So what's the role of a company secretary? The company secretary performs an administrative role for the company. The primary role of a company secretary is to ensure that the company fulfills its reporting requirements. Does the company need to have a company secretary? Proprietary companies are not required to have one, although they may choose to have one. The company secretary is appointed by the directors and is accountable to the board. In smaller companies, a director will also generally act as a company secretary. So who can be a company secretary? As an officer of the company, the requirements for being a company secretary are the same as a director, such as the person must be over 18 and not be bankrupt. A company secretary is also subject to the same duties as directors, such as the duties to act in the best interests of the company and to exercise due care and diligence. Subject to the company constitution, any director has the power to call a meeting of directors. In practice, this will be delegated to the company secretary if there is one. The director secretary must comply with the notice and quorum requirements for directors' meetings as specified in the Constitution. The default position under the Corporations Act and the replaceable rules under the Act is that reasonable notice must be given to all directors, and a quorum of at least 2 directors must be present or participate in the meeting. The notice should be sent to the address of the director according to the company's register of directors or as notified by the directors. A defect in notice or a lack of quorum will not necessarily invalidate the meeting or any decisions made at the meeting unless it causes substantial injustice to the affected parties. Directors can participate in meetings in person or through the use of technology agreed to by the directors, such as teleconferencing, Skype and webcasts. It is good practice for directors to observe the following principles. Board meetings should be held regularly to afford directors the opportunity to have a robust discussion about important matters and to ventilate any issues. A board pack containing the meeting agenda and any documents or materials to be tabled or discussed at the meeting should be circulated to all directors well in advance of the meeting. The board pack should not be too long. The aim is to encourage directors to read it. The board pack should incorporate, for example, executive summaries. The board pack should aim to align the agenda with the company's organisational culture, its goals and strategies. In other words, the board pack should assist the directors to drive the business of the company. As I said earlier, the director's fundamental responsibility is to drive the company business forward. Meetings should follow the agenda to avoid getting sidetracked. Directors make decisions by passing resolutions, either at the meeting or by circulating a resolution signed by all directors. A company is required under the Corporations Act to keep a minute book containing a written record, in other words, the minutes of the meeting and the resolutions. The minutes must be made within a month of the meeting, should be signed by the chairperson within a reasonable time of the meeting, should be kept at the company's registered office or principal place of business or other location notified to ASIC, and may be kept in electronic form provided they can be reproduced in written form. Even if the company has a single director, that director should record and sign their decisions in the form of minutes. Some tips. The minutes are a record of the meeting, not a report of it or anything else. The minutes should aim to strike a balance between simply recording the decisions made and also providing some context, such as the factual background, the items considered and discussed by the directors, and documents tabled. There is indeed a skill in knowing what to include and what to leave out. The minutes do not need to record the individual votes of the directors. They only need to show that the board resolved by a majority to take a certain action, although individual directors may wish to have their dissents or abstentions noted for the record. The minutes should be recorded by the company secretary. The board should have a clear understanding of the role and powers of the chairman in running the meeting and signing off on the minutes. Issues such as whether the chairman has a casting vote are very relevant, and that the board should have a knowledge of that well in advance of the meeting. The chairman or company secretary should promptly circulate the draft minutes to all directors for approval and any suggested changes or corrections. The minutes should be approved at the next board meeting. The approved minutes should be signed and initialed on each page by the chairperson and entered into the official minute book. The company should implement controls to ensure electronic copies of the minutes are not tampered with. And quite importantly, the minutes can provide a good summary to brief management on the board's decision to drive the business of the company. As discussed earlier, it is in the interest of the directors that the minutes record why a certain decision was made, especially a controversial one, including the rationale for it, where there may be a conflict of interest, a related party transaction, or a decision requiring a business judgment. It should record any disclosure of personal interests and delegations of authority and the issues considered by the directors, particularly where there's a conflict of interest, a risk management issue, or a solvency issue. Properly recorded, minutes may assist directors in defending themselves against an action for breach of duties. Please contact me if you would like more specific assistance in this area. The company secretary is required to keep and maintain the registers of the company, including the registers of members or shareholders and the registers of directors. The registers may be kept in a hard or soft copy at the company's registered office, principal place of business or other location notified to ASIC, and failure to do so is a criminal offence. The company should also issue share certificates to shareholders and number them, retain signed original share transfers when they have been recorded, retain copies of any personal guarantees, for example, given by directors, retain copies of signed consents and resignations of directors and secretaries, retain original contracts entered into by the company, and maintain control of the company seal if there is any, and keep bank authorities current. Some of those issues are good housekeeping issues, but nonetheless very important. The company secretary should notify ASIC within the stipulated time frame of any changes to the company's registered details and complete the annual returns. Most of these notifications can be made online. It's important to remember that the ASIC register is a public document, so companies should keep it up to date. Apart from being legal requirements, good corporate housekeeping will also be helpful if the company is ever sold. It will show a paper trail and a chain of ownership of the shares, the extent of the directors or the company's liabilities. So what corporate secretarial services can a law firm provide? Companies often engage lawyers to provide corporate secretarial services, and Folbigg offer the following: advice on corporate governance matters and directors' duties, preparation of forms, share transfer forms, notices of meeting, directors' consent, board resolutions, maintenance of company records and registered, notifications to ASIC and the ASX if relevant, and advice on the company constitution and any shareholders agreements or preparation of a shareholders agreement. We will ensure your paperwork is in proper running order and allow you to focus on running your business rather than worrying about administrative or compliance issues. Please contact us if you would like our assistance. Just briefly looking at financial record keeping. Company directors have financial record keeping duties under the Corporations Act. All companies are required to keep and maintain accurate financial records which correctly record and explain the company's transactions and financial positions and would enable true and fair financial statements to be prepared and audited if necessary. Financial records can be stored electronically and must be retained by the company for at least 7 years. So what rights do directors, both current and former, have to access financial records? A company must make its financial records available at all reasonable times for inspection by a director. Former directors may also inspect the books and records of a company for up to 7 years after they cease to be a director, provided the inspection is related to current, pending or anticipated legal proceedings. A former director can also contract with the company to provide broader access rights than are available under the corporations legislation, and obviously that contract should be put in place before the director resigns, or ideally before the director is appointed, so the director knows where he or she stands once they cease to be a director. Now, turning briefly to liabilities, a company director who fails to take all reasonable steps to comply with their obligations under the Act could be liable for on the application of ASIC for a fine of up to $200,000 and the company up to $1 million. They may be found guilty of a criminal offence if they behave dishonestly. They may be disqualified from acting as a company director, and they may be required to pay damages or restitution to the company if the company has suffered loss. Turning to the shareholders, the other important organ of the company. They are, after all, the owners of the company. However, we should think about what that means. They have a proportionate interest in the net assets of the company after it is wound up. the shareholders do not directly own the assets or property of the company. Those assets belong to the company, which is a separate legal entity. The company can own its own property and enter into contracts, sue and be sued. That's, after all, why people establish a company. The distinction should be maintained even in single-member companies. The shareholders should not treat the assets of the company as if they were the personal assets of the shareholder. Sounds fairly fundamental, but should be remembered. The company should have a separate bank account and obviously maintain its own set of books. The company should avoid commingling company funds and shareholders' funds, and also client or customer funds if there are trust monies involved. The company should not use company funds to pay the personal expenses of shareholders or directors. Company should not make any loans to shareholders unless it is in the best interest of the company to do so. While shareholders have the benefit of limited liability protection, they could also be liable for the debts of the company if they act as a shadow director and are somehow instructing the directors how to perform or carry out their duties. Or if the company becomes insolvent and they have benefited from voidable transactions, such as uncommercial loans or unreasonable related party transactions, in which case they will be required to repay the money to creditors. Or if they have been a director of the company, in other words, they would be liable in that capacity. So what's the relationship between shareholders and directors? The shareholders, as I've said, are in essence the owners, and the directors are the managers. So the directors must manage the company in the best interests of the shareholders and not according to their own personal interests. They must also act in the best interests of the shareholders as a whole. In other words, not discriminate against certain shareholders or favour majority shareholders over minority shareholders. The board is accountable to shareholders. The board reports to the shareholders, and the shareholders can appoint and remove directors. The shareholders make their decisions at a general meeting of shareholders or via written resolutions in smaller companies. It is good practice for the company to hold regular general meetings of its shareholders. Only public companies are required to hold an AGM. Shareholders holding at least 5% of the votes may force a company to hold a general meeting. Shareholders should be given an opportunity to be heard and to ventilate any issues at a general meeting. And the board should report on any pertinent issues to the shareholders and to seek their approval, and it's best practice in my view, even when that's required by law or the company constitution. The company should observe the notice and quorum requirements set out in the constitution, whilst an irregularity in that will not necessarily invalidate the meeting unless a substantial injustice occurs. Accurate minutes of any meeting of shareholders should be recorded. This is required by law, and the same principles apply to directors' meetings. So what is the balance of power between directors and shareholders? As stated above, the directors exercise all the powers of the company, except those reserved to the directors in the general meeting under either the Corporations Act or the Constitution. The Corporations Act mandates that certain decisions can only be made by the shareholders at a general meeting by way of a special resolution, in other words, 75% or more vote in favour. Such things as altering the Constitution, altering the share capital of the company, such as a reduction of share capital or subdivision of shares, altering the rights attaching to shares, or changing the company's status from a proprietary company or a public company are matters that require a special resolution and cannot be removed by a company constitution. In other words, the shareholders must deal with those matters. A company constitution can confer certain additional powers on shareholders, such as a veto over certain actions, such as a sale of the main business of the company or assets of the company, or the issue of new shares, or rights of preemption and rights of first refusal when new shares are issued or an existing shareholder wishes to transfer their shares. The shareholders may amend the constitution at a general meeting to give themselves greater rights or to reduce the discretionary powers of the board. The ASX listing rules also contain additional rights for shareholders, but they're only applicable to listed companies. So what are the remedies available to a shareholder if they don't like how the company is being managed by the board? Aside from selling their shares, which could be impractical in a small company where there's no real market for the shares and may be restricted by rights of preemption or similar, shareholders may take action against the company and or the directors to remove the directors by a vote at a general meeting, or apply to the court for orders, including damages or an injunction stopping certain steps, or requiring the company to buy back their shares, amend the constitution, or wind up the company. Clearly, an action such as that would be very expensive and often a last resort. A shareholder may also apply for orders if the directors have breached their duties and caused loss to the company. The company is being run in a manner which is oppressive or unfairly discriminates against minority shareholders. The company is unwilling to take action against a shareholder for breach of duties, or there is a deadlock at board or shareholder level, and this cannot be resolved. So what is and why have a shareholders agreement? A shareholders agreement is an agreement between the members or shareholders of the company in relation to the affairs of the company and how that company will be run, how they will exercise their voting powers at a general meeting for the shareholders to drive the business of the company forward insofar as those matters are within the shareholders' power. A shareholders agreement may include such terms as an understanding or a statement of the business activities of the company or what activities it will pursue to give the board guidance, the entitlement of certain shareholders to appoint directors, rights of preemption and first refusal in relation to share transfers, rights of redemption for a shareholder and of how those shares would be valued, a right to inspect company books and records, and any veto rights that the shareholders may have. There may be different classes of shares on issue with differing rights, such as preference shares and ordinary shares. Those rights should be documented in both the Constitution and the Shareholders Agreement. The benefit of a Shareholders Agreement is that it sets out the agreed arrangements and understanding of the shareholders at the outset. Hopefully that will help minimise disputes. It will confer additional rights on shareholders. As outlined above, the Corporations Act and the Constitution contains few rights for shareholders, so a shareholders agreement can enhance those rights. A shareholders agreement is a private document, unlike the constitution of a public company, so it can say things that may not necessarily be said in a publicly available document. The signatories may sue to enforce the agreement. As an agreement, it's only binding on the signatories. It cannot be enforced against the company unless the company is also a party. And generally, it will not prevail over the Constitution if there is any inconsistency. So it's recommended that unlisted companies with multiple shareholders have a shareholders agreement. Although you may go into business with friends or family and may trust your business partners, at least initially. Our experience as lawyers is that disputes often arise, and it is better to have some form of preemptive action in the form of a document. We can assist you to draft a tailor-made shareholders agreement which is appropriate for your company and business, and hopefully that document, if it's signed, will provide some protection against problems. So just to wrap up, I've emphasised that directors are subject to onerous duties and obligations. They must remain vigilant, exercise their powers with competence and independence. They must avoid conflicts of interest. Good record keeping should help directors and explain why they did what they did. Directors have financial record keeping and reporting obligations and generally cannot outsource their responsibilities. Poor corporate governance and workplace culture can impact and result in poor financial performance. Shareholders have certain rights under the Corporations Act, the Constitution and any shareholders agreement. So directors should engage with shareholders and are ultimately accountable to them. Directors, shareholders and company officers should also seek advice if they are unsure of their rights and responsibilities, or if they need assistance in drafting a constitution or shareholders agreement. What is a sensible level of governance will depend on the size of the company and the business it conducts. Good governance should assist and not hinder you in achieving your corporate goals and running your business. I have, look at the time, I have received some questions which I will have a go at answering. So just excuse me while I do that. The first question is, please elaborate on the safe harbour and business judgment defences. The business judgment defence has been around for many years and is a recognition that there is an inherent risk in any business decision, and if the directors are going to drive the business of the company, they must make decisions. Courts won't second guess a decision of the board made in good faith. In the absence of other factors that might give rise to liability. The safe harbour provisions, which commenced in late 2017, protect directors from personal liability for debts incurred by an insolvent company if after the director starts to suspect that the company is insolvent, the directors develop a course of action that is reasonably likely to lead to a better outcome for the company. Another question, can I predict any future trends? I think the Royal Commission has put corporate governance back in the spotlight. I think that hopefully we'll see that corporate governance is seen as a must-do for a company. I think insurers and lenders will force companies to be more aware and compliant with basic risk government procedures and issues. I think insurers and companies will force that on companies with risk-based pricing. Question here, what would I say to anybody who's been offered a directorship? I think I'd say think carefully about what you're getting into. A directorship is more of an obligation than a status symbol, and you should also think about separating the risk from your personal assets. Typically by putting your assets in your spouse's name, that too is fraught with risk. So as we've said, a directorship is an obligation and should be taken very seriously. Why should I, another question from Ruth. What are the requirements for maintaining signed documents in the register? Can documents be signed electronically by virtual cabinet, or are the documents required to have an actual signature? I think, Ruth, my view would be an electronic signature would be sufficient, but there should be some form of signature. Without a signature, I think it's difficult to say that the person actually turned their mind to the document. So a bit old-fashioned in that regard, but I like to see a signature and ideally an original one. Another question, why should I worry about all of this if I'm a sole director shareholder? Now, issues such as conflicts of interest and good communication typically won't be relevant in such a scenario, but a sole director company still has to be managed to prevent insolvent trading. Proper delegation to staff is still relevant, and good record keeping is also relevant in a sole director company. Typically, a sole director company or shareholder won't have a good business succession plan and will be relying on the sale of that company or business to fund a retirement. So, as ever, it's good to have something in good condition when it comes to selling it. So I would encourage even a sole director to have a well-maintained company with evidence of good governance, so that when the time comes to sell, hopefully it should be easier to sell and a good price will be received. That concludes my presentation for today. Thank you for your time in tuning in. And if you need any further advice or assistance, please contact me at Matthews Folbigg to discuss any issue. Once again, thank you for your time today.